Good afternoon, everyone. We're going to go ahead and get started. I hope everyone is staying healthy and safe. On behalf of Majeure Woods as a firm and our litigation, real estate, land use practice team lawyers, I wanted to thank everybody for making the time to attend today's webinar. We had over 300 registrations for this webinar, and I would really like to thank everyone for their attendance today. We've got a really great program, panel of Majeure Woods attorneys covering the very timely topic of real estate contract implications amid COVID-19 concerns. In today's program, our panel is going to talk about dealing with issues surrounding COVID-19 and how they're dealing with those on the ground right now with our real estate clients. Obviously, there are a lot of issues that touch on every aspect of our clients' businesses, but today we're going to focus and limit the discussion to many of the contract enforceability issues that are arising in the real estate contract context. As you hear from my colleagues momentarily, we also, as a firm, are tracking and providing advice on many COVID-19 issues, and we've outlined in some of our introductory slides information about the firm and our COVID-19 task force, and we welcome everyone to visit our website and view our latest updates. And also the slides will be available to all attendees, and we'll share a copy following the presentation. By way of introduction, I'm Scott Adams. I'm a land use and real estate partner at Majeure Woods based in normal times in our Tysons office. I'm also the chair of the firm's land use practice group. I'm joined today in introducing and moderating this panel by my fellow partner, Greg Regal. Greg is the managing partner of the firm's Tysons office and practices commercial real estate law with a concentration in land use, zoning, and redevelopment matters, and has more than 30 years experience in the real estate development industry. And Greg is also an active member of the firm's COVID-19 task force. Our panelists today include a really fantastic group of litigators and real estate transactional attorneys that are bringing their significant experience to bear on the new issues arising as a result of COVID-19. Our first panelist is John Wilburn, who's a litigation partner based in Tysons. John is an experienced trial lawyer who concentrates his practice in construction, land use, eminent domain litigation around the country. And John represents all major constituencies in building-related projects and litigates a variety of construction matters before all tiers of the state and federal court system, including bid protests, design defects, and acceleration and delay claims. Our second panelist is Rick Holzheimer. Rick is also a litigation partner based in Tysons, and Rick's a trial attorney with extensive courtroom experience who concentrates his litigation practice in construction, commercial litigation, government contracting, financial services, and real estate. And Rick has represented clients in all aspects of the construction industry, including owners, contractors, subcontractors, and design professionals, and has a broad range of experience that includes contract disputes, trade secrets, financial service disputes, employment litigation, government contracting, product liability, eminent easement issues, successor liability, zoning issues, and general patent litigation. Our third panelist is Alan Gordon. Alan is a partner in our real estate department based in Pittsburgh who concentrates his practice in real estate transaction and has worked extensively with commercial, healthcare, and industrial clients on a wide array of transactions covering the full cycle of commercial property, including land acquisition, construction and construction financing, leasing, permit financing, and disposition. And Alan's substantial experience includes negotiating and completing real estate acquisitions and sales, commercial real estate development projects, commercial leasing, and the formation and negotiation of partnerships, joint ventures, and other entities. Our fourth panelist is Kang He. Kang is an associate in our commercial litigation group in Tysons and is a rising legal star. Kang's practice is primarily focused on commercial litigation and eminent domain work, and he advises Fortune 500 companies, government contractors, and small businesses on matters related to contracts, construction, employment, business torts, and zoning. As a bit of quick background on Majeure Woods, Majeure Woods is a full-service law firm with 1,100 attorneys based in 21 offices worldwide. Our real estate and land use team consists of 90 team members, including partners, counsel, associates, and land use planners. Our overall real estate practice is a diverse one that spans a wide range of traditional, non-traditional real estate transactional litigation matters, and generally all aspects of real estate. And our clients range from regional organizations to Fortune 500 companies, which gives us a broad perspective and enables us to provide streamlined services. On the litigation side of the house, we have upwards of 100 lawyers who practice in the complex commercial litigation department, advising clients regionally, nationally, and globally. And as we hear from our team today, our lawyers have extensive experience advising clients on construction, commercial litigation, government contracts, financial services, and real estate issues. Both of our real estate practice and our litigation practice are national in scope, and I think we're all happy to introduce you to colleagues from across the Majeure Woods platform if you reach out to any of the folks on the panel today. So with that, I'm going to turn it over to my colleague Greg Riegel to talk about how Majeure Woods is generally addressing client needs related to COVID-19.
Thank you, Scott, and thank you, everyone. And hopefully many of us on this panel are not strangers to a good number of the folks on this webinar. And for better or worse, we wanted to highlight some of the broader firm perspective, just because for better or worse, what we're all dealing with is the ultimate multidisciplinary issue. And Scott touched on some of the resources that are available, and I would certainly commend everyone's attention to the materials that are published on our website. They're updated daily, sometimes multiple times per day, and there's a lot of good information on everything from the regulatory side, the labor and employment side, and the incentive side. And in fact, we have a slide up here talking about our incentive practice, which is one of the largest in the country. And we put it up here with a certain amount of perhaps optimism in that what we're dealing with now will not be a forever circumstance, and there will undoubtedly be a number of incentives and economic development opportunities coming out of this situation. And the folks in our peer organization, Majeure Woods Consulting, monitor those continually. And I also encourage you to take a look at their resources on that subject as well, as it's highly, highly relevant to the real estate industry. As I touched on, we take the whole situation incredibly seriously. And we also try to take it from a practical perspective, and I think that will hopefully come through during the presentation today. We are not going to give you a law review style review of the issues and the opportunities. We're going to try to keep it in a very practical frame that is hopefully useful to the real estate challenges all of you face. Let me also say or emphasize that this is sort of the start of a discussion, not the end. And certainly after this session is over with, if there are other subjects that are of interest to you, please let me know, let Scott know. You can also use the question function on the webinar. And if we need to reconvene for a more focused look at any other topics that are central to the real estate industry, we will gladly do it in the coming days or weeks. Before I turn it over to the panel, a couple of practical things. As all of us have learned in the past few weeks, keep all your devices on mute. That helps with the audio. For the lawyers on the call that are interested in taking advantage of the CLE opportunity, the code is SPRING with a capital S 2020. And from a question and answer standpoint, we will try to hold those until the end, and Scott and I will keep a watchful eye and try to organize the questions as best we can. And if there are questions where the time parameters don't allow for a response, we will commit to follow up with you offline. And in fact, can even get the answer to the collective group of attendees. So anything you ask is tracked, and if we don't get to it today, we will certainly get to it in a follow-up form. So enough of the preliminaries. I'm going to turn it over to my partner, John Wilburn, and John will start with the concept of force majeure, I believe.
Yes, thank you, Greg, and thank you, everybody, for participating today. And as Greg mentioned, there's a mechanism available to you to submit questions, and as those pop up, we'll try to make sure we get them addressed today. I'm going to talk first about force majeure, and probably nearly every one of you on the phone has experience with the concept of a force majeure clause, and probably very few of you have ever had occasion to either invoke that clause or to defend against a party invoking it to relieve themselves of the obligations under their contract. But as you're undoubtedly aware, we're in a very unique time. The coronavirus that is impacting our country and our industries has had an impact of a type never felt before. And so I think as we move through this, these doctrines that we're going to talk about today, which are rarely invoked, are likely to be front and center in litigation over the next several months after the courts open. What's driving this specifically is not only the pandemic that is so highly contagious and has caused people to want to not go out in public and not go to places of work and to not work if they have the opportunity to work, but also, importantly, the government's unprecedented restrictions on travel, large-scale gatherings, and the restrictions on businesses that are not deemed essential businesses. Fortunately for the construction industry, at least in Virginia, and I think in most jurisdictions, construction is still deemed an essential business when it goes to certain categories, including residential development, hospital development, some other types of important infrastructure development. So construction is still ongoing. The question is, how does this pandemic impact contract performance? And in particular, where there is an impact, will the doctrine of force majeure and the related but common law doctrines of impossibility, illegality, and frustration of purpose impact your ability to either enforce the contract or to excuse performance by you if you need to do that? We've also seen a significant number of insurance claims for lost business or business interruption being asserted. I'll talk a little bit about that, but you should certainly, if you've had your business interrupted, take time immediately or as soon as you can to look at your insurance policies and determine whether there may be coverage for this pandemic. Oftentimes there's exclusions for viruses, but not in every case. And we've been looking at some of those policies and finding opportunities to recover some of those lost business damages. But you want to make sure you meet your notice requirements. And with all that's going on right now in the world, it's important to pull those policies out, take a look at them, and make sure if even there's a chance of obtaining coverage that you're meeting those important notice requirements. We only have an hour today. I've already taken up too much time, I think, on just the general introduction, but I want to talk about these key legal concepts, the first being force majeure. We also have impossibility and frustration of purpose.
And we identified it this way because it's really how you look at it. The first place you should go is your contract, as John pointed out, which will have the force majeure provision. Next up, as we'll get into, is impossibility because it's a strong doctrine. And finally, for the third principle of frustration of purpose, we put that last because it's going to be the most difficult to enforce. So we've set up today's call to kind of go through it from the strength of contract to the doctrine of impossibility and ultimately to kind of a catch-all if needed.
Generally speaking, force majeure clauses excuse a party's non-performance when an extraordinary event prevents the party from fulfilling its contractual obligations. The applicability of force majeure clause is contract specific. It's traditionally a very high bar to overcome, and the language of the contract will govern whether the defense will apply. It's the starting point for this is to look at the contract itself and determine whether the event giving rise to the request for excuse from performance applies. You also must show that performance is truly impossible, not simply impracticable or more expensive. It's an objective test. The court's inquiry largely focuses on whether the event giving rise to non-performance is specifically listed as a qualifying force majeure clause in the agreement. And so in this case, if we're talking about COVID-19 or a pandemic or a virus, I've had occasion over the last 30 days to look at an awful lot of force majeure provisions, and I haven't seen those specific concepts, pandemic, virus, or disease, in any of the agreements that I've looked at. So, sort of superficially, you would say that it's not covered, but it's important to look at all of the language in that force majeure clause for other terms that may exist. Often these force majeure clauses have catch-alls like act of God or disaster or emergency. These are some that we've seen. And I think that those are the types of words that will largely be litigated as these things move on. You all should also look for the concept of governmental regulation as an excusing event. That's often contained in force majeure clauses, and here we clearly have that. I think as of this morning, all but 9 of the states have imposed stay-at-home orders. We've got guidance from the CDC, which is not a law or regulation, but it's being followed by federal government regulations, state regulations, and even local regulations that are either restricting the ability to work or to engage in commerce, or where they're allowing it to continue, like construction sites, imposing additional restrictions on, for example, workforce management. You know, how many people you can have on a job site, how close they can work with each other, what sort of personal protective gear, health, safety, environment measures have to be put in place in order for them to work. All of those additional impositions create cost and impose time on those businesses, and in particular construction and contractors that are trying to continue to work. When you look at these force majeure clause, sometimes they are labeled force majeure, sometimes, and in the construction industry more often than not, they're embedded in time delay clauses. And so you want to make sure that when you look at your contract, that even if there's not something in force majeure, your contract likely has provisions in it that allow for the contractor either to suspend performance, obtain additional time for performance, and money for performance for delays beyond the contractor's control. For example, the AIA documents clearly do that. And I think, frankly, nearly every construction contract that I've seen has some sort of time and compensation component for delays that are outside the contractor's control, which this would likely be. So when you're looking at these clauses, make sure you look beyond simply the force majeure language and look elsewhere in the document to see where there might be an opportunity if you're asking for the additional time to invoke it, or if you're not asking, if you're defending against it, make sure it would be covered. One thing I'll point out on this is it's very important that you understand what your notification requirements are, particularly in construction contracts. When you're asking for additional time or money associated with any event, whether it's a force majeure event or some other change in law event or some other occurrence like this, you've got to meet those deadlines. Jurisdictions vary in terms of how aggressively they enforce the deadlines, but some, like Virginia, are very aggressive. Others, like the District of Columbia, are not aggressive at all. And the notice provisions vary. Under the AIA standard form, it's 21 days, so it's a pretty generous period of time to identify the existence of the either supply chain or workforce issue or a shutdown order or some other imposition associated with this pandemic, and identify that to your counterparty in the contract to invoke the additional time provisions. But I've seen it as recent as 24 hours. You've got to do it within 24 hours. I've seen language that says contemporaneously. So even though it does feel fairly obvious, I think, to many of us that practice in the construction arena, that the events that we're describing will likely be grounds for additional time, additional compensation, it's important that you make sure that you're following those notice provisions, or that you're insisting upon your contractors or downstream suppliers that they're following those as well, or you may lose the opportunity and the benefit that they are intended to provide.
And as we go through each of these principles, we do want to talk about some of the general principles that apply to all of these defenses: force majeure, impossibility, and frustration of purpose, including ideas such as the burden of proof. For all of these, the burden of proof is going to be on the person seeking to invoke the doctrine. So it can apply to both sides, but whoever is seeking to use the defense is going to have the burden of proof, which is pretty straightforward. Other straightforward concepts, but they get a little more subtle later: materiality and the essential purpose. What is being held up? What is being stopped? Is it going to be something that is vital to the project, or is it going to be shipments of landscaping or something that is really not going to hold up the project? So looking as to what is being held up and what is being barred is going to be important for force majeure purposes and impossibility and frustration. Another concept such as foreseeability and assumption of risk, that's an interesting one. Includes a lot of things. There may be some language in the force majeure, or when you're getting into the concepts of impossibility and frustration of purpose. How foreseeable was it? Pandemics We've had other things that have been declared, such as SARS. There was Ebola, obviously, not too long ago. But the issue is going to be is how foreseeable was COVID-19. And so the issue of having ongoing pandemics may be something said, look, we've had these for years, but I think it's safe to say that COVID-19 is at a different type of level, is a different type of pandemic. So while pandemic may be used broadly, I think we're going to see a lot of people say that COVID-19 is a different animal.
It is. It's going to be a hard argument for anybody to make that the contracting party should have foreseen the events of COVID-19. We did have SARS, we did have Ebola. None of those resulted in the shutdowns that we're experiencing today. They were managed, and businesses continue to operate, projects continue to be built. So I think on the foreseeability element, that's likely to be easily satisfied. It's also only relevant under a force majeure analysis if you're relying on one of those catch-all provisions like disaster or act of God. But I think that's going to be relatively easy to satisfy. You see on the screen, causation is the fourth element. Coming out of this, I think that you're going to have a group of people, a group of businesses that simply struggle to perform directly because of the COVID-19 crisis and the regulatory impositions that the government is insisting upon. But you will also have some contractors, some counterparties to contracts who invoke these arguments in a pretextual way. They were otherwise insolvent, they were otherwise not performing on jobs, they'd abandoned projects, they'd lost the ability to either deliver the materials, to build the structures, or otherwise perform their contractual obligations. So, you shouldn't look at the current state of affairs as just a blanket get out of jail free for parties to these development and construction contracts. Some beyond superficial analysis should be made to determine whether the counterparty was in fact ready, willing, and able, financially and otherwise, to perform their obligations. If not, the force majeure defense, as with these other common law defenses we're talking about, fails for lack of causation. The next issue we've got here is permanent versus temporary. Sort of falls into the same logic discussion that I just set forth. We are on a temporary shutdown, presumably a temporary shutdown, and it has a dramatic impact on a party's abilities to supply projects or perhaps build, or in the case where construction is ongoing, these additional safety measures you have to undertake. But it does not necessarily mean that a party can abandon the contract. What a court will look at is whether it was reasonable or what the contract may provide, but failing that, whether it was reasonable for a party to walk away from the contract under this environment or to effectively, hold it in place until these restrictions are lifted, until the supply chain is restored, till the workforce is able to move as necessary to project sites, till the regulatory impositions are relaxed. And so you need to be wary if you're an owner-developer of contractors who use this as an opportunity to walk away from jobs that they either improperly bid or that are financially infeasible at this point, or that there are other reasons why they want to move away from it. I've got a circumstance exactly like that right now where one party is limited in the ability to perform the contract because of some of these regulatory impositions, and it's more expensive and will take more time to actually build the project than the parties anticipated at the bid stage. And there's a mechanism under the contract to give notice of the reason for the delay and to request additional time and additional money to do the work. Instead, what the contractor's done is send a notice of termination, simply citing COVID-19 and force majeure. That's an issue that we on the owner-developer side are going to have to address, but I feel fairly confident that when courts reopen, that simply giving that notice in this environment will be found to be a breach of the agreement. Now that said, one thing that I want to emphasize here is I said at the beginning that force majeure clauses are rarely successfully invoked. It's a high bar, burden is on the party seeking to invoke it, and courts are dubious of those arguments. But I think we're going to see a complete shift in the body of law on that force majeure defense when courts reopen, and because I think courts are going to be sympathetic to this very unique environment we're in, and despite the fact that parties have not specifically contracted to include pandemic or disease or virus in their agreement, and may not have the catch-all like act of God or disaster, courts are going to be struggling, I think, to find reasons to relieve parties of their contractual obligations where these other elements are met: causation, materiality. That's my sense of this, and we're seeing it in the few cases that have come out of circuit courts before the court shut down. We've seen that kind of strained analysis to reach those results. There's one case, a circuit court case that I can circulate. It's not on our PowerPoint, but a Virginia Circuit Court judge was looking at whether whether a party was entitled to additional time or relief given the COVID-19, and there was no provision in the contract that specifically contemplated relief, but the court found that there was an issuance of a national disaster, and that the Virginia Code defines disaster to be a communicable disease, a public health threat, and the court sort of read all of that into the parties' arrangement and allowed for more time. I think it's not an analysis that you would have seen prior to this epidemic, but I think we're likely to see a lot of that going forward.
Getting to the issue, the heart of the issue is going to be, is COVID-19 considered an act of God or a national emergency or a national disaster? What we're seeing, and again, the courts are mostly shut down, what we are seeing is courts are taking this seriously. When you've got the President of the United States, governors for the vast majority of the states, and even the chief justices of various courts are issuing orders saying these are national emergencies, and because of that, certain orders are going into effect. So, just picking Virginia at random, you've got the United States president who said something, the governor has said something, and Chief Justice Lemons issued an order finding that there was a national emergency, a state emergency, a judicial emergency, and because of that was entering emergency orders. So now that the courts have actually spoken, and we even have a Fairfax Circuit Court judge who has said and examined the issues and said, these are national emergencies, these are issues.
Yeah, you'll see up on the slide now, this is the one question we received before the presentation. Is COVID-19 considered an act of God? We've cited in this response 3 cases, 2 Virginia Supreme Court, 1 out of D.C. Act of God traditionally has been interpreted to mean natural disasters, so hurricanes, floods, tornadoes, those types of things in environments where they could not reasonably be expected. For example, in where I grew up in Oklahoma, a tornado is probably something that is foreseeable. You get them every spring, and if you don't build it into your force majeure clause, you're probably not going to win it under an act of God provision. Same thing with hurricanes, perhaps in Florida. But generally speaking, violent acts of nature that are beyond those that would be expected in the ordinary course fall under the act of God phrase. But I think in light of what we're experiencing now, and we couldn't find a case that had reached this result yet, but I think it is more likely than not, and probably strongly more likely than not, that courts will find this COVID-19 pandemic an act of God, and they'll do it because it clearly, I think, was not foreseeable that even with a viral outbreak of this type, that the country would be placed on lockdown in the way that we have. And even in the construction industry, the regulatory impositions that have been imposed on those projects that are still underway are not the types of things that were done under prior viral outbreaks. So I think it's more likely than not the court will find that it is an act of God. There's one case we cited. I don't think it's particularly applicable, but it's the only case in Virginia, the Sanders against Coleman, 1899, where the court found that a disease was an act of God that allowed the party to avoid a contract. But it's an antiquated case. It was a marriage contract. I don't think it has a lot of applicability here, but we added it because it is the only case that deals with disease as an act of God, at least in Virginia. And there, the Virginia Supreme Court did find it was an act of God, and I think it'll be an easy and comfortable step for most circuit courts to adopt that holding and apply it to the COVID-19 circumstance.
And kind of dealing with an act of God and also natural disasters. Again, while courts are basically on lockdown and are only hearing emergency issues, we did get an opinion from one local circuit court as of March 30th, so pretty recent in time, dealing with criminal matters and whether or not there was a natural disaster for purposes of speedy trial. And I want to bring this up. It's obviously clearly outside of the construction issue, but we want to show what the judges are thinking. And here, this judge was trying to figure out, what he had to do in order to maintain having trials, examined whether or not the coronavirus was considered a, quote, natural disaster. And this judge went through a long analysis and ultimately said it was a natural disaster. So once a judge is on record saying something is a natural disaster for one purpose, it is likely that that judge and the other judges are going to find that COVID-19 is a pandemic for other purposes as a natural disaster, presumably for civil purposes. So we think that, what's going to happen in a couple of weeks or whatever period of time when the courts opened up, we think that the judges really are looking at this differently and will likely find that this is a pandemic, a natural disaster, or an act of God.
On the next slide, I'm going to skip past this one, but we've given some examples of when force majeure is unavailable. I don't think these are apropos to the COVID-19 problem, but they go to circumstances that were obviously caused by the party seeking to invoke it. So if your own negligence or malfeasance caused the delay or caused the problem about which you're complaining, you will not get any relief under any of these doctrines. If it was something that was foreseeable and you didn't build it specifically in the force majeure clause, again, tornado in Lawton, Oklahoma in the springtime, you shouldn't rely on disaster or act of God. So these are some examples, but I think COVID-19 is going to largely fit within certain of these, and certainly the common law doctrine of impossibility or illegality. We'll talk about that. We'll talk about that now. And for those of you who don't have a specific either delay provision in a construction contract or a force majeure provision in any contract, you're not without relief if you're seeking to get relief from these contracts. There are several legal bases under which you still can seek an extension of time or for your contract performance to be excused. They come under several common law doctrines I mentioned earlier: impossibility and frustration of purpose. The underlying premise for these doctrines is that some unforeseen and unexpected event has made contract performance impossible, or in some states impracticable. Now, Virginia and Maryland and most states, it's impossible. There are a few states where impracticability is the standard, like California. But for most, the court will look at, was your performance rendered objectively impossible by this circumstance that was outside of your control, was not foreseeable, that actually caused your non-performance. And if that's the case, then performance can be excused.
So looking at the doctrine of impossibility, it's going to be important to figure out, examine exactly what your contract provides, because obviously this is an extra contractual provision, something outside the contract. But if your contract is a choice of law provision, look to those states and that court in particular as to figure out how this legal doctrine could apply to your contract, because it's not something that was bargained for. So getting into the issue of impossibility, it's not a question of frustration, or it's not a question of impracticability. It is meant to be impossible. Because this is an extra contractual defense, the courts are going to have a high burden for it. So when they say impossibility, they mean it is impossible. And that can take on any forms, whether it's factually impossible or legally impossible. And for something like COVID-19, we think we have a combination of both for everybody. Let's start with legally impossible. Start with the governor's order. The governor has specifically ordered that certain businesses, certain types of activities, and certain areas are barred, can't occur and cannot occur, and people cannot do it. It is officially illegal. As such, we think that's a strong basis for impossibility. If you are not considered an essential service or authorized by the governor of Maryland, Virginia, or the mayor of D.C., that would have a strong argument of being illegal. And by being illegal, we think courts are going to find that it was impossible. It is very it would be very unlikely that a court would say, while the act was illegal, you still had an obligation to do it. So we think illegality is going to be probably the strongest the strongest reason to invoke the doctrine of impossibility.
I think one of the challenges for probably the group of clients that we're talking to right now is that you're largely within an industry that the governor has said is essential. So you're in this really, I think, awkward place where most of the country is shut down, but the government has said that your line of business, which is construction, remains an essential function. And so you may not have available to you the illegality argument. You may not have a force majeure provision that is satisfying in the sense that it covers these issues. And yet you've got to continue performing under a contract or insist performance of a contractor to you in an environment where, I keep going back to these impositions, but there's a project that I'm dealing with in D.C. and it's still underway. It's a residential construction project. And, the foreman that I talked to is struggling with navigating the trades in and out while maintaining the required distance between, the tradespeople. And they've been required as of last week by DC government to use masks, and he's got workers who are complaining about that. But there is a project management burden that I think a lot of people haven't experienced in terms of how to manage the workers and the tradespeople on the job itself in an environment where you're not being excused by the government with its order. You still need to perform, but you need to perform in a way that keeps these employees and tradespeople safe, that helps you avoid fines and citations from the government, and the inspectors are out, at least on this job and another one I'm aware of, pretty regularly looking for violations on these health and safety impositions. So I think Rick, one of the challenges here is it's not as simple as it is for some clients where the government has found their business to be non-essential and they can't operate except perhaps remotely. This industry needs to continue functioning by virtue of the government's order and ongoing contracts.
Yeah, John is absolutely right. And under the present orders, real estate and development and construction is allowed to go forward. So absolutely, that makes sense. But obviously, the coronavirus situation has been changing. Governments have been taking stricter and stricter requirements as the virus has progressed. So we don't know what's going to happen. But John's absolutely right. For the doctrine of impossibility, for right now, the construction industry seems to be excluded, is being excluded, and so we hope that it continues to allow it to go forward. And then getting into the issues that John talked about, such as, scheduling, keeping people apart, these are all things that do not meet the requirement of impossibility. So an increased difficulty or an increased burden or, unfortunately for a lot of our clients, unprofitability, the fact that this is unprofitable or difficult is not impossible yet. But impossibility can come in through other methods. Right now, construction can go forward because there are materials to do it. But depending on how long this goes on and what sort of orders are in place, at some point it may start affecting materials, deliveries. While construction is an essential industry, the issue is going to be, is a brick factory or is some sort of lumber mill, is that considered part of construction? So as you get farther up the chain, you're going to be a little more removed. So hopefully the issue resolves itself quickly, but as time goes on, supplies are being used and people are being used, and to the extent the DC mayor requires masks, if they're unable to get masks, how is a construction project to continue if there's a requirement to wear masks and they don't have masks?
Yeah, I just think practically speaking that these things become cumulative at a point. So even if you're not excused for performance under the contract because of illegality, impossibility, or force majeure, there is a cumulative impact to, decrease in the supply chain, restrictions on worker movement, and then impositions of health and safety on the job itself that make the project perhaps, unmanageable. But the risk is, if you're arguing the other side of that, you say that just makes it more expensive. And there are mechanisms in your contract typically to deal with and address additional impositions and expenses, and you do it through change order. So, when you're looking at these from either side of the equation, I think it's important to be well aware of not just your force majeure rights, but what does your contract say about delay, increased cost, increased time, expense, and most importantly, notice. Make sure that you're following it, and make sure that you insist upon either downstream, or counterparties on these contracts that they're doing the same. One other, I think, practical challenge that I've seen that we're wrestling with is being consistent. You've got to understand what position you're taking on a project, or you may have a need to, or client may have a need to seek relief from a lender, or seek relief from a particular contract counterparty while trying to resist similar relief from someone else on the project. And I think I've already seen that in a couple of cases where, a client seeking relief because of COVID-19, but then wondering why, or objecting to relief from a different person on the project. So I think there's just so many sort of moving parts on this, particularly for clients who operate in different jurisdictions. The laws that we're describing sort of general and focused primarily on Virginia and DC, but the law varies by state. The safety impositions vary by not just state, but even locality. What you're seeing, varies there. So if you're operating in different states and with different projects and different contract counterparties, it is an awful lot to manage. But the risk is that most of your construction contracts build in mechanisms to adjust for this, and you need to be mindful of those notices. And Rick's waving me off, so I think we're getting close on time. Go ahead.
We're good. And we wanted to touch briefly on frustration of purpose, and then obviously get into leasing issues. And we put it in this order because frustration of purpose is going to be probably the most difficult defense to raise, and it's going to be the most factual intensive. So force majeure, contractual impossibility, which is a common law defense. Frustration of purpose is also a common law defense, but it's definitely one that's going to have probably the highest bar of all of these defenses, because it's so broad and because it's so nebulous as to what the concept is. It's going to be dealing with defense to the contract, which again was not bargained for by the parties. So a court is going to be very, very reticent to find that the defense is valid for frustration of purpose. So it has to go to that their purpose for the contract or the project or whatever is frustrated such that the project is useless without it. So while impossibility dealt with the thing to be performed, frustration deals with the reasoning behind it, the purpose of the contract. So if you're building something, and I'm going to take an extreme statement, you're building a 10,000 person stadium, and because of this virus, the government bars assemblies going forward of more than 1,000 people. That's going to frustration purpose. It has to be something rising to that level to do it. So it's going to be very difficult to have. We wanted to raise it. We want to say that there are some other general principles, but force majeure is probably the strongest, and impossibility next, and this. And we want to switch over now and turn it over to Alan. We've got some other slides, but we wanted to get right into commercial leasing and make sure we save some time.
Thank you. Let me get to where I need to go on the slides. Okay, so as John and Rick explained, the situation that we find ourselves in now, people have been using the word unprecedented, which I think is a very accurate description of it. And the courts are basically closed. They're not hearing these kinds of cases. Litigation, judicial relief is months, if not years away on this. And so the question is, to some extent, what do you do now? And most people have leases. You're either a landlord or a tenant, depending on your, where you are in terms of, do you own it or are you leasing property and are you leasing it to others in the commercial context? And so what I want to go through is, I want to look at this and help us look at it from the tenant side. I want to look at it from the landlord side, and then I want to also talk about what we're seeing in the market in terms of deals that are being made or things that you might want to consider if you have to approach your landlord. Usually what happens is the tenant is sort of the moving party on this because the rent is due, or the rent was due on April 1st. And, now the question is, well, what do we do? So as a general proposition, as I said, the tenant really is the moving party because it has the obligation to pay the rent. the first thing, as John talked about, is what does the contract say? And it's no different looking at a lease or a commercial construction contract. What does the contract say? What's very interesting about force majeure provisions in leases, and if you haven't looked at one, you would look at it and shake your head and say, how is it possible that that's what it says? But I would say 90 to 95% of commercial leases, the force majeure clause will list all kinds of force majeure. It will typically exclude performance by both parties, but then it will have a catch-all that says, but this does not forgive the tenant from its obligation to pay rent or any other monetary sums under the lease. And so you'll have a force majeure clause with what I'll call a catch-all, you must pay the rent provision. And if you look at it and you read within the four corners of the document and you're a tenant, you look at it and you say, well, that's what it says. What do I do? And the answer is, I don't think that's the be-all and end-all of the discussion from a tenant perspective here. And I'll get into that when we talk a little bit more about where the tenant's coming from in a minute. The other items from a general perspective is, this is relationship driven. If you have a long time left on your lease, I think as somebody mentioned earlier in the introduction, the sense I think that people have is that this too shall pass and that we will be back to something in terms of more commercial norms than we're seeing right now. And if you have a long-term lease, you certainly want to be careful on both the landlord and the tenant side not to burn any bridges here. I think that that's an important component to what's happening and how you might want to approach this from either the landlord or the tenant side. The other general concept to keep in mind is what I'll call business reputation. So if you're a tenant and you're considered, for example, to be a credit tenant to a landlord and you have 5 leases with the landlord in 5 different shopping centers, you might want to think very carefully about how you're going to approach the landlord and how you're going to do this, because if you're not as good now as the landlord thinks you were before this started, that may have implications to you going forward in terms of, and we'll get to this in a second, the landlord asking perhaps for more security, a higher security deposit, or the landlord asking for an additional guarantee or for a letter of credit. All of that may come into play as you think about how you're going to proceed and how you want to manage the relationship between the landlord and the tenant as this moves forward. One other issue on lease guarantees, which is a very unique issue, and you may see it, you may be living it. If the lease was assigned, then it is possible that there's what I'll call an old guarantor on the lease. That is, the business was sold, the original lease was guaranteed by a principal of the original business or by the parent company of the original tenant, and the lease has been assigned, the business has been sold, but the old guarantor remains out there. And often in the purchase of the business, there's an internal indemnity between the parties. The new buyer will indemnify the guarantor or the old buyer for these kinds of things. But now you've got your buyer that's having these problems. If it's a retailer, for example, and it's not picking up as much revenue, you have an old guarantor that's sitting on the lease, and you have a landlord that might say, hey, that's great. I'm just going to go after the old guarantor here because they're still solid. And it could create a real business problem between the current tenant and the old tenant relative to what's happening. So that's something just to keep in mind as we work our way through. All right, so let's talk about how this looks from the tenant side as we look at this and as we see what we're trying to do here from the tenant's perspective. Okay, so number one, we're looking at what type of lease is this. So what you're seeing in the newspapers and in the media, I guess I date myself when I say newspapers, but what you see in the media is a lot of big box retail stores are saying to their landlords, I think Cheesecake Factory announced last week they weren't paying the rent. We're not going to pay the rent, Mr. Landlord. We're not doing it. And retail really has been hurt. A lot of their revenue, especially in the restaurant business, has been hit very, very hard. They don't have the revenue coming in. they're basically saying to their landlords in a unilateral way, and we'll talk about it versus unilateral versus collaborative in a second. They're saying to their landlords unilaterally, they're sending out letters, we're not paying the rent. Office is a little different because some office is still deemed to be essential. You're able to work, and plus, people are working from home. They're tying in, they're working from home, and so that you can still have your office tenant use moving forward in a way that is allowing revenue to be generated by the business so that its financial hardship may not be nearly as great as the retail hardship is. Then you've got industrial, which is probably kind of in the middle. I think it depends on who the warehouse is doing work for. If you're doing cross-dock shipping and you're still able to do it, your argument that we're being hit hard by the coronavirus crisis and we can't pay the rent may fall on deaf ears. If you're closed, you can't operate, you don't have any ability to drive in any customer revenue, it's a better argument. So that leads to point number 2 on the list, which is, are you really in financial need, or is this part of the analysis of, hey, the landlords are hurting, or the landlord's given a break to my neighbor, why should he get a break if I'm not getting a break? I'm going to ask for a rent abatement or rent deferral. I would say I've cautioned tenants about that because one of the things when we get to the landlord slide you'll see is we are certainly recommending to landlords, and I think it's good landlord practice, for the landlord to ask for financial information, financial statements, evidence, a plan going forward of why it is that the tenant is unable to pay the rent, and not just to take the tenant's word for it at face value. So that's going to come into play. Revenue, we talked about, are you really having revenue interruption, or are you, and what's the extent of that in terms of how, when, and why you're going to approach your landlord. We're looking at, are you open for business or are you closed? How long do you have left on the lease is a critical point, which goes back to the relationship in the general considerations. And when we get to what deals can you make, we'll talk about why remaining duration is important. Okay, so items 6 and 7 to me are the 2 most important. I probably should have put them as 1 and 2 rather than 6 and 7. 1 or 6, unilateral versus collaborative approach. If you're going to be collaborative, and sometimes you can't be. I mean, if you have 1,000 store locations, you really can't go one-off. It's hard to go one-off with your landlord. But if you're going to try to be collaborative, you have an office lease, you're a tenant, you're going to work with your landlord. You want to be measured, you want to be reasonable, you want to approach this as we're all in this together, and we need to shoulder this burden together, and you need to think about it and walk the landlord's mile a little bit in terms of how to approach a deal with your landlord under the circumstances. Then number 7 is a little bit of a nuanced point, but you need to think about it. So if you have, let's say, 1,000 stores, but you have 10 stores that are key drivers of your revenue, that if you lost those stores, you would have big issues relative to the being able to replace them in that market or to find another place to put them. You might want, your strategy might be, I'm going to not mess around with that store. I'm just going to pay the rent on that store, and I'm not going to worry about whether or not I have enough revenue to pay 1,000 leases. I'm going to pay 5, and here's one of the 5 that I'm going to pay. The other thing is, if you have multiple stores with the same landlord, you might want to be careful about how you deal with that landlord because their reaction to you may be unilateral in terms of dealing with you, and all of a sudden you've got multiple stores at risk where if the landlord takes a very aggressive position and says that's a default, the force majeure clause says you must pay the rent, you might not want to put that relationship at risk. So I think from the tenant's perspective, those are the things that we ought to be thinking about when you think about how are you going to do this and what do you want and what do you need. Okay, so now from the landlord's perspective, how's the landlord looking at this and what should the landlord be considering as it works its way through this process? Okay, 1, from the landlord side of the house, everything needs to be in writing. You do not want to be in a position as a landlord where this turns into a fight later on, that when it makes it to the court, there's a, well, he said or she told me that I could do this. You don't want to be in a course of performance argument situation where the tenant hasn't paid the rent, you haven't objected to it, and the tenant continues to not pay the rent for a few months, and then in month 4, you turn around and say, hey, you didn't pay the rent, you're in default. You want to be clear that you as the landlord are performing under the lease and that you're not in default, that you've done everything you're supposed to do. If you're doing extra cleaning for the office building, for example, if you're following CDC guidelines, you want letters going out to your tenants saying, we're doing everything and more. We're doing what we were supposed to do under the lease plus, and you want to identify what that is. Also, you might want to send out an email or something that says to your tenant, this is all preliminary discussion. Unless and until we reach a written deal, there is no deal, and nobody's bound by anything that we say. It's only what we do in writing that counts. As I mentioned before, you're going to want to see what you're going to want your tenants to show you that they're having financial problems, that it's related to the COVID-19 coronavirus situation, and you're going to want some sense of how is this, what's the timeline, and what do we think is going to happen going forward, and how is this affecting you, and what do you think this looks like? And you're going to want to understand that. When you look at a deal to be made with the tenant, you need specific time periods and terms. You do not want to wait and see. Pay the rent for March, pay the rent for April, and then we'll see what happens later on. Is not a deal you want to be making as a landlord. You want to be very specific about the time periods. You want to consider whether or not now might be a time to say the tenant's in default, take part of the security deposit, but still work out a deal with the tenant, but at least have some cash in hand, because when we get to what the deals look like, landlords still have expenses. They got to pay their mortgage, although we'll talk about that in a second. They got to pay utilities. They got to pay taxes. So the issue becomes, can we take down or will we take down some of the security deposit now to pay for some of those things? And when you, Mr. Tenant, are in better financial shape, you'll re-up the security deposit at that time. But in the meantime, we have some cash in our pocket. Abatement of rent versus deferral. The difference in my mind is when you abate the rent, you're not really looking for repayment of it in the strictest sense, although the term can be extended of the lease. Deferral, you're deferring the rent, you're looking for repayment over some period of time with some amortization of that amount. We talked earlier, I think, about building operating expenses, CAM, and taxes, which is the landlord still has these other costs that are being incurred, and those aren't going away. So how do we as a landlord make sure that we're at least collecting enough money to pay our out-of-pockets as we move forward? Okay, number 8, very interesting. We haven't really touched on this yet, but the CARES Act has a number of provisions. The main one that people are talking about is the Payroll Protection Program, the PPP loans, in which small businesses can get an SBA loan and get loan forgiveness for payroll, mortgage, interest, utilities, or rent. And landlords, I've seen this, and we've counseled landlords to try to do it, and try to have the tenant say, listen, if we, the tenant, get a PPP loan, the landlord wants you to pay some of that loan portion that's going to be forgiven to us as rent. Under the guidance that came out last week from the Treasury Department, the guidance is that you can't use more than 25% of it on non-payroll related stuff for forgiveness. That's not what the CARES Act says, but that's what the guidance says. So as a landlord, the pot of money that you can pursue is a little bit more limited than it might otherwise be with that 25% limitation. But it's not a bad idea to say to your tenant, and we have done this, go apply for this, and if you get it, we want you to pay some of that to us against the rent that we're abating or deferring. The next one on the list is, we talked about this, so I'll jump by it quickly because we're running out of time. Get a new guarantee in place. or get confirmation from your existing guarantor relative to anything that you're doing. The last one is mortgage payment suspension possibilities. So again, this relates to the CARES Act. The CARES Act provides, and also there was an announcement about a week and a half ago now by the Comptroller of the Currency, the FDIC, the Fed, that they will work with lender banks on, the lender bank does not have to declare the loan to be a non-performing loan or a TDR restructuring loan if the lender works with the landlord borrower to modify the loan, suspend principal and interest payments for what they call a short-term period. In the statement that came out, they had referenced that short-term period with the parenthetical that said 6 months. What we are seeing in the market right now is really a 90-day provision that if a landlord goes to its lender and it's a relationship lender or a non-CMBS lender, what we are seeing is that the lenders will generally, and of course it depends on the lender, it depends on the landlord, give a 90-day suspension of principal and interest payments, which then the landlord can then work with its tenants on non-payment of rent in a collaborative way. The other thing to keep in mind from the landlord perspective is when you amend critical leases, oftentimes that's a covenant in your loan covenants, and you need to make sure that your bank is aware that you're amending the critical leases, because if you do it without their consent, sometimes that may put you in default under the terms of your loan documents. All right, so let's talk about what's happening in the market. What do deals look like that are happening here? And, how you can think about it from your perspective as to what makes sense for you in your individual or corporate context relative to deals. So abatement versus deferral of rent. Abatement is the tenant's not paying and it's not going to pay that rent. That rent is disappearing with a magic wand. Deferral is we're not going to pay that rent now. We're going to pay it over time later. What we've seen and what seems to be the trend is non-payment, abatement, or deferral of rent for April, May, and June. Some are April and May. A lot are April, May, and June. If you defer it, what we've seen is the reamortization or the payment of that rent starting in January of 2021 over either a 6 to 12 month period with some interest component on it. Okay, number 3 is all rent versus only base rent. And number 4 is the payment of monthly pro rata share of CAM or BOE. These are related points. If usually the rent is, there's 2 components to rent. The base rent component and what I'll call the additional rent component. Base rent is the basic rent, X dollars per square foot that you're paying. Additional rent is your pro rata share as the tenant of the common area maintenance charges in retail or building operating expenses in office. They're the same thing. They just have different names, basically. Taxes and sometimes insurance, although usually insurance can be a BOE or a CAM charge. So from the tenant perspective, you can build an awful lot of goodwill with your landlord. And remember, if this is a long-term relationship, goodwill matters. If you offer the landlord up instead of, I'm not going to pay any rent, you say, I'll defer or I'll abate the base rent, but I am going to pay you the CAM or the BOE and the taxes, my pro rata share of that. That will give the landlord some cash flow. It allows the deal to move forward and it creates goodwill. I say on both sides, but it certainly creates goodwill with your landlord. Okay, next item. Extension of the lease term for the payment for the period of rent. If you're going to abate rent, it's very common. So you take a 3-month abatement of rent. Usually you'll extend the term for that 3-month period to allow the landlord to become whole by collecting the amount of rent, number of months of rent that it was expecting to get when it started the lease. Again, a good faith, reasonable offer by the tenant to extend the term. Okay, last one is negotiating or extensions and renewals. So this is a little bit of art, way more than science. So if you have a lot of lease term left, negotiating a renewal might not be the way to go. If you have a short amount of lease term left, some landlords are saying to their tenants as part of this, if you want a rent abatement, you want a deferral, we want you to exercise your renewal option for the next 5-year renewal that's coming up, and we want you to commit to a longer term by exercising that option. If you're the tenant, one of the things that I think you have to think about from a business perspective is it is likely, and I don't think anybody has a crystal ball, but it is likely that the COVID-19 coronavirus pandemic is going to result in some tenants not reopening. They just will not be able to take the hit, the shock, the cash flow shut-off that's been so immediate, and they were already having trouble. They will not be able to take the hit. They will never reopen. So if you're a tenant now and you think you're going to reopen, it might make sense for you to wait, to resist the landlord's request that you renew your option, because renewal options right now, the market rate or what you're looking at in the renewal term, if it's a flat rate increase over the current base rate, is probably going to be higher if the market really softens and a lot of tenants go out of business. If you're a surviving tenant, your ability to negotiate a better renewal rate or general rate with your landlord may benefit by waiting and by time. So a landlord is pressing right now to say, if you want this abatement, I want you to extend or renew. A tenant's pushback is going to be, I don't need to do that. I don't want to do that. I can't pay the rent anyway right now. So why do I need to be in a position of renewing? Let's try to cross that bridge when we get to it later. Let's see how this works out, hoping that the market will be better for you at a later time, which I think at least short-term logic would tell you that probably is going to be the case if a bunch of tenants aren't able to reopen. So I think that hopefully is a good overview for you to see what we're looking at, how we're trying to work through this, what we're recommending, and how we're trying to frame the analysis for landlords and tenants as we work through, I'll use the word again, this unprecedented situation. So I'll turn it back over to Scott to see if there are any questions or comments.
Thanks, Alan. Yeah, we've got a lot of very good questions in right now, and I'm going to let Rick Holtzheimer jump in to start answering some of those.
Okay, try and take these. Maybe they're a little out of order. One question was, do the principles of force majeure, impossibility, and frustration of purpose, do they apply with equal force to other types of contracts? The answer is yes. So these doctrines apply generally across the law of contracts. I think I may have referenced them a few times in the context of construction, but they apply to every contract. So the answer to that is yes. And if your contract you're concerned about today is not a construction contract, these doctrines apply to whatever you may have.
Yeah. So to construction, real estate, any type of contract.
All right. There's a question: if a nursing home tenant receives relief through a government program, they should be able to pay rent. Would they be able to claim force majeure and ask for rent relief? What defense would the landlord have? Well, it's going to depend on, number one, the language of the lease specifically, but generally, if the tenant has the ability to pay the rent, regardless of the source of sums, then they have an obligation to pay the rent. So, it goes to this argument we raised earlier. One of the elements of force majeure is causation, and impossibility is, you have to show causation. So for the tenant or any party to be relieved of an obligation, they would have to show under these doctrines it's impossible to perform it. And under this fact pattern, it doesn't sound as though it's impossible for the tenant to pay the landlord the rent because they have access to the sums elsewhere. What's the next one?
Next question is, there could be a failure to perform based indirectly on the pandemic and directly on government action mandating a shutdown. What defense would be most applicable?
It could be all three of them. If the contractor can't perform because of a government shutdown, then the doctrine of impossibility would apply. The doctrine of illegality might also apply, and the doctrine of force majeure may apply depending on the language of the force majeure clause. So you look first to the force majeure clause to see whether it's covered, but even if it's not, impossibility likely provides the defense in that circumstance.
The next question we have is regarding statute of limitations, and if there was a cause of action that could not be filed because of court closure, would the statute run during this time?
And the answer is it depends on the state. Right now, for example, Virginia, the Supreme Court has invoked a state of emergency in the courts by statute that tolls the statute of limitations and all other court-mandated deadlines, but you need to be careful of two things. One, understand the state that you're in, because even though there's an emergency declared by the government, there may or may not be an emergency declared by the courts as a result. Probably is, but maybe not. Second, there's an expiration on this emergency. I think it's April 26th.
In Virginia, yes.
In Virginia, so every state will vary, but there will be a tolling, but it's state specific.
Okay. Our next question is, for materials coming from China that are specified by the plans and specifications for the project as manufactured, would the owner be at risk for the dedicated specification requirements if these materials received were contaminated and people get ill, even though they were ordered and procured by a subcontractor?
The owner would be at risk of being sued because if somebody gets sick on a job, it's likely that the plaintiff's attorney will sue everybody in the chain of custody of the materials, the plans. But the owner should have substantial defenses to it. Specifying a particular material or product, built into that is typically the implied warranty that is fit for its particular use, and in this case, that it's functional and not diseased. So I don't think the owner would be liable in that circumstance.
Okay. Our next question is, if an out-of-state subcontractor is allowed to work in D.C. but can't work due to the laws of their state, does the general contractor have a delay claim?
Yeah, I hate to hedge on this one. The answer is probably yes. Many contracts require in a construction case, the general contractor will submit a list of proposed subcontractors to the owner who will approve them, or if not approve, object to them. So if in this circumstance you have an out-of-state subcontractor who is ordered by their state to stop working, I think that's an unforeseen condition that would likely entitle the general contractor additional time. I think it almost certainly would under the AIA documents, and beyond that, it depends on your specific document, but probably yes.
Okay. Our next question is, would delayed opening insurance as an extension to a builder risk policy provide coverage in the event of a delayed opening due to government shutdown? The insurance policy indicates that loss of rental income and delayed startup expenses would be covered in the event of delayed opening. These are for residential apartment buildings, high-rises, and hotel high-rises. However, the delay must be caused by a, quote, physical loss or, quote, direct physical damage to the insured property during the period of insurance.
This is a great question that is going to be, I think, litigated heavily. I'll give you my understanding of the answer, but Greg, this is one I think we should separately follow up on. We've got a COVID-19 business interruption insurance team that has very specific answers. But the challenge here, I think the questioner put their finger right on the challenge, is most of these policies require a physical impact or physical damage is the language in the policy. So the question is, does COVID-19 effectuate a physical damage to a property? I think there's a strong argument if you in fact have somebody at the property who is diagnosed with COVID-19, because then you're required to go through a whole series of decontamination procedures, right, that presumably mean the property itself was damaged. If the delayed opening is a result of a general shutdown, I think it's going to be a tougher argument. But again, Greg, I would direct some additional feedback to this question from our insurance COVID team.
Okay. Our next question is, with paraphrasing this a little bit, with all of the government programs such as the Paycheck Protection Program available, will landlords require tenants to apply for those programs like Paycheck Protection Program?
Landlords may ask for it. Landlords, I don't think, can require it, but it's a similar question that I had earlier, which is, can a tenant be relieved from rent? And if the circumstances, like illegality or impossibility or force majeure apply, they may be relieved from rent, but you still have a duty to mitigate, meaning if you can pay the rent or some portion of the rent, you have an obligation to do it. I don't think you can make the tenant apply for PPP, but if they have or if they otherwise have the funds, then their defense, if they are sued for non-payment, either for eviction or recovery, their burden is to show that one of these defenses that we talked about today applies, and the response to that might be that you didn't mitigate your damages by applying for this PPP. Of course, separate from all this, many jurisdictions have imposed moratoria on evictions, and the courts themselves are closed. But when they reopen, I think that that's going to be, I think what you described is going to be an interesting issue. But I think the tenant has to show that they tried to mitigate and they could not pay. And if PPP is available to them, I think that's a good argument for the landlord.
Next question is, if you take a security deposit early for rent, what are the preferential treatment issues if the tenant goes bankrupt within 90 days? Would the deposit be considered a preference and clawed back?
Yeah, this is one, Greg, I think we need to get an answer from our bankruptcy team. My understanding of the bankruptcy implications is not sufficient that I'd be comfortable giving an answer, but we can get the question or an answer on this pretty quickly.
Okay. New question. Would you recommend that landlords use forbearance agreements whether or not abatement or deferral is granted? And if so, may the landlord legally include tolling of statute of limitations clause?
Yeah, Alan may have some views on this one. I think you talked a little bit about this, but I think a landlord can use a forbearance agreement. And you can always include a tolling of the statute of limitations if you can get the agreement of the parties. Right now, as I mentioned, statutes of limitations are tolled, at least in Virginia and in many other jurisdictions, but parties are free to contract for that between themselves.
I agree.
All right, and the next question is, how, if at all, would the defense of force majeure, impossibility, or frustration of purpose apply to a homeowner who's already in default on their mortgage loan and in foreclosure proceedings when the pandemic began and states began issuing shelter-in-place orders?
Yeah, this is a great question because it's going to come up a lot. This goes to the causation elements for each of these 3 or 4 defenses we talked about today, and you will get a lot of what I think are pretextual assertions of these defenses, meaning on a foreclosure, if I'm already in default, haven't paid my mortgage in 6 months, and foreclosure proceedings are imminent, right now the state is staying all of those proceedings. Can the landowner, argue that they should be relieved of foreclosure because of this? I think they'll make that argument, but it's going to be a tough one because of causation. They went into foreclosure prior to the pandemic itself. Maybe there's some argument that they will be able to make that they, could have gotten a job or were unable to work and cure the foreclosure, but I think it's going to be a tough one. This sounds like a pretextual argument by the homeowner.
And those are the questions that we have. Greg, back to you.
This is thank you, John, Rick, and Alan. This is Greg Regal again, and I wanted to thank everyone for the thoughtful questions. And as John alluded to, this is a very helpful exercise for our COVID-19, frankly, in terms of understanding what's on your minds in terms of practical business issues or things of that type. And we will follow up on the interruption insurance question and the bankruptcy question. In this day and age of efficient online communication, we've got good contact information for everyone, so we will get back with you on that. You will also receive some additional information from us that does have contact information for all of the panelists, and if you have a specific question or a derivative of the question you've asked, by all means reach out, and that's, as the expression goes, what we're here for. Needless to say, some of these topics we could have spent an entire 90-minute session on individually. And similarly, if there is a topic that you think would be interesting to delve into deeper, we'd welcome that feedback as well. You could easily spend, I think, the entire session from a landlord perspective or a tenant perspective, and suffice it to say that this is all changing by the day and by the minute, I think, as everyone is aware of. To that end, finish where I started, would commend your attention to all the materials that are posted on the firm's website, both out of the law firm and our affiliate Majeure Woods Consulting, if you're interested in the incentive side and what states and localities are doing. And I'll join all the panelists in thanking everyone for the time and thoughtful questions in what is a very interesting and trying time. And if you want to end with an optimistic note. While we've been on this call, the panelists have somehow talked the stock market up another couple of percentage points. So maybe that's a high note we can end on. Anyone on the technical team, do we need to do anything further to wrap this up, or have we got it covered? Hearing none, we will declare this webinar to be adjourned. And again, I thank you, and please let us know if we can be of further assistance.